Good morning. Thank you for joining me. I am Victoria. I am one of the estate planning attorneys with the Koppenbarger Law Firm. I primarily help our clients in our Northern California areas, primarily San Jose, Sacramento, and Santa Cruz. So if you're in those areas, I look forward to getting to work with you if I haven't done so already. And if I have, welcome back. Now, we do have quite a few attorneys and offices, so let me introduce you to some of the attorneys. First and foremost, we have our founder, Lloyd Koppenbarger, who is in our estate planning department. He still actively practices to this day. We also have attorney James Kosareff, who is the head of our estate administration department. One of the things that we are all aware of is that at some point our loved ones or ourselves are going to pass away. And so it's incredibly important to make sure that you have an attorney there to help guide you or your loved ones through what comes next. If somebody has passed away, what do I need to think about? What legally do I need to deal with? And what can Koppenbarger do for me? And really, practically, can you help me see what do I need to do for the family and for myself as time goes on? Then we have Larry Koppenbarger, who's another attorney in our estate planning department. He actually helps me run the department, but he primarily works in our Southern California offices. So if you're in the Pasadena area, the Orange County, San Diego, and even Temecula areas, you will likely run into him. Then Sunny Bourne is our business and tax attorney. So again, one of the things we are aware of is that with estate planning, there's more than just setting up an estate plan. For a lot of our clients, they're concerned about rental property protection. They may have a small business they want advice on or need protection for. And then for others of our clients, they have advanced tax questions that she is then able to address. Robert Galliano is the main attorney in our Temecula office. So again, if you're in that area looking for estate planning needs, he is likely the one that you will meet with. Then we have Kimberly Parkins and Monica Braun-Hendy. So they are both newer attorneys to our estate administration department. And so again, if you unfortunately are dealing with the loss of a loved one or you need help on what now comes next, they are part of the team that helps our clients answer those questions. And then we have Stan Hutchinson and Tony DeGasperin. These two are attorneys of counsel for us. What that means is that recently we acquired their law firms as they were looking at going into retirement and wanted to ensure that their clients had an attorney that would continue taking care of them in the ways that they had done for their careers. They, though, are of counsel for us, which means that we are able to pick their brains on all of the knowledge that they have and have them help their clients transition in to meet with us. Now, we could not, as the attorneys, do what we do without the help of our absolutely incredible staff. This staff is one of the largest for estate planning firms in the state of California. And again, we could not do what we do without them. If you are already a client, odds are you have met with quite a few of them. But if you're not a client, you will very much get to meet them as time goes on. And then I've already mentioned a number of our offices. And so again, this really adds a huge value to our client base, not only because they know if they move within the state of California, odds are we have a physical location in their area, but also their families may be spread out throughout the state. And so we're able to do a lot more in-person meetings than many other firms would be able to, simply because we have so many offices. But we do understand that even though we have this many offices, it still may not be in your immediate area. And so what's great with Zoom is that we are able to meet with people virtually and still have a somewhat face-to-face meeting and get to help you with whatever your needs may be. So that's a little bit of background about us, again, for those of you who haven't already worked with us. But now we're going to focus on what is this webinar going to cover. So during this webinar, again, it's going to be a really good crash course in what is estate planning, why is it so important to work with a qualified attorney so that you avoid any disasters that we encounter, but then what happens as time goes on? What do I need to be aware of once I do have an engagement or relationship with the Koppenbarger Law Firm? Are there things that make you stand out and make this firm really go above and beyond many other firms in the state? And so we'll go through all of that today. And just as one final reminder, if you have any questions or anything that you want specifically addressed, please throw it in the Q&A and chat. And again, we'll pause a couple times to make sure that those get answered. All right. So first and foremost, what do you need for an estate plan? So with an estate plan, we're not just talking about a will or a trust. A lot of people, those are the two most common terms that they have heard, and it's will or trust. However, when we are looking at your estate plan, it really should cover a wide variety of documents. You at a minimum, if you are over the age of 18, actually need the Advanced Healthcare Directive and Durable Power of Attorney. Those are the two foundational documents that, again, every single adult needs to have in place. Whether you think you're ever going to use them or not, these are crucial to ensure that if you are ever in a position that you cannot advocate for yourself medically or financially, that someone is named to do that for you. Then we start looking at, do you need a will or a trust? For the vast majority of our clients, they end up needing a trust, and I will explain why in just a minute. But for any attorney that you are trying to figure out, should I work with them or not, if they are not mentioning you at a minimum need the healthcare and durable power of attorney, then please do not pick those as the attorneys you work with. Because again, these are foundational documents that every person ends up needing. So first and foremost is that Advanced Healthcare Directive. So again, this is the document that actually names who is able to act on your behalf and make your medical decisions if you are no longer able to communicate with a doctor. Now, legally, back in 2004, the law changed to say that nobody has an automatic right to make your medical decisions, not even a spouse. And if you're a child who has turned 18, your parents no longer have a legal right to even know what room of a hospital you are in if you have not given the doctor the authority to do so. So if you are in a position that you can verbally no longer do that, you need to have in writing who has that authority. The other piece, though, with a healthcare directive is that it is your chance to give end-of-life care instructions. So this is where you can talk about organ donation, life support, burial versus cremation, things that, frankly, the family doesn't want to have to guess at what your wishes would be. It can add a lot of stress relief and a lot of peace to have your family know this is precisely what they would want now that they can no longer make their own choices. That peace of mind is something that I was able to use for a family member just a few years ago, and it really did have that truly peace of mind knowing that I was carrying out her wishes rather than taking a shot in the dark and hoping that I got it right. But then there's also the issue of who would manage your finances in the event that you were incapacitated. So if you are somebody who is incapacitated, bills unfortunately still have to be paid. Those credit card companies are still going to come knocking and make sure that their statements are covered and maintained. And so if you are in a position that you can no longer manage those things and can't maybe remember to pay bills, or you're just physically not in a position that you are able to do so, you want to make sure that you have named who can do that. Now, in some cases, if you have a spouse or someone else on the assets, it's not as big of an issue. But if you have things like retirement accounts, or you don't have somebody else named on your assets, those are things that then would sit idle while you were in need of them, but could not get to them. And so again, this durable power of attorney just helps ensure that you are able to actually have your finances managed if you are no longer able to do so on your own. Then we start looking at, okay, now I know I need the powers of attorney for medical and financial, but what else do I need? Do I need a will? Do I need a trust? And why would I need one over the other? So the purpose of a will is essentially to have at a bare minimum something in writing that says where your stuff would go once you are gone. Now, one of the questions I had received is, what is the difference between an executor and a trustee? With an executor, that is the person named in the will. That is the person where if something had to go into court or your will needed to be settled once you were gone, they are the person that would do that. So I'll pause there and get to trustee in just a second. But you are not going to be properly protected with a will if you own real estate and or have an estate greater than that $184,000 number. So if you are sitting here and own a piece of property, or let's say have $200,000 in an account, then a will is not going to properly protect you and your assets once you are gone. Now, if you are the parent of a minor child, you need a will regardless of the other two parameters. And the reason is that in your will, that is where you actually name the guardians of those children if something happened to you while they were still minors. But the reason I say that a will is not enough if you own real property or have more than that $184,000 is because once you pass away, it would mean your estate was subject to probate. Now, this is a state requirement, so this is not something that we have created. This is what the state says would have to happen. Essentially, probate is there so that if you only had a will, the court then makes sure that accounts are settled, debts are paid off, and ultimately things are transferred from you to your beneficiaries. Again, this means that it is a court process because you're having the court have to get involved. Anytime the court is involved, two main things happen. One, there are significant delays in being able to actually settle somebody's estate. And two, the cost of settling that estate goes up astronomically. One of the things that we have seen is for the average home in just California as a whole, being about $1 million, which is quite a high number, the cost of probate is anywhere from $40,000 to $60,000 just if you had a home with a gross value of $1 million. So you can imagine how much probate ends up taking out. Now you'll notice I also said the gross value. The court does not care what equity you had in that home. They care what the actual value of that home is. And so truly, when we're looking at what is subject to these probate fees, we're looking at gross value of things, which can absolutely deplete an asset or an estate down to the bare minimum before the beneficiaries ever even see a dime. The other issue with the probate component is that, again, they have their own rules. And so the control is with them and not the family. And so when we're looking at probates, a lot of times families, they're ready to settle, they're ready to get it done. They don't want to deal with the court. But because it's on the court's timeline, it could take, on average, 2 to 5 years to settle a probate. That is an extraordinarily long amount of time to be stuck waiting for the court to ultimately distribute the assets of the one who has passed away. And so again, this is something that ultimately we are trying very hard to help every single person avoid. And so again, if you own property or you have more than that $184,000, then a will is not going to be correct for you. Now, let me just jump into the Q&A really quickly and see if there was anything here. Okay, not quite. There's a few sections down the line. All right, so the next up is, how do you avoid those things that I just talked about? How do we ensure that probate does not happen? Well, the main way is by using a living trust. And so a living trust is something that is actually a contract that you, as the what we call settlor or creator, sets up. You get to set the contract terms and determine who would manage things on your behalf that are in the trust if you no longer could, and ultimately, where do things go once you have passed away? So with the living trust, we generally are talking about what is called a revocable living trust when you hear that term. The reason we talk about revocable trusts is they are changeable and revocable as time goes on. One thing that we talk to every client about is the fact that at some point or another, your estate plan, whether it's the full thing or just a portion, is likely going to have to change. And the reason is your estate plan is essentially on your life cycle. A lot of times when our clients first come to see us, the needs they have on day one are very different than the needs 10 to 20 years later. And so again, it's important to keep in mind, you, for the most part, want a trust that you are able to change and keep up to date to ensure that everything stays relevant. Now, one of the big questions is, what is the difference between a living trust and a lifetime asset protection trust, and the advantages and disadvantages of each? Generally speaking, we recommend revocable trusts for our clients. Now, there are some people with exceptions where they really do need more advanced asset protection. And a lot of times that's coming down to they're concerned about creditors or lawsuits. With the revocable trust, everything is still under the client's social security number and in their control. And so if you could be sued as an individual, your trust does not actually prevent you from being sued, even if your asset is in it. Again, for the revocable side. If though you have this lifetime asset protection trust, generally speaking, that is then looking at irrevocable trusts that lock the asset in. The advantage to that is it is an asset protection. So if you are in a lawsuit, you're in a car accident that's 100% your fault, the asset cannot be touched. The disadvantage, however, is with most irrevocable trusts, you have to give up control and even benefit of those assets. So for a lot of our clients, they are not interested in asset protection trusts because they don't want to give up control and benefit. And so there's other things we then start talking about, up to and including working with a good car insurance or property insurance agent. A lot of times insurance is where you can ultimately ensure that assets are going to be protected. We also then can point you in the direction of our attorney, Sunny Boren. So that's also where then we're looking at our LLCs, something that is appropriate for you. If you have a rental property, odds are we should be talking to you about the option of an LLC to prevent any lawsuits or creditors that could arise because of the asset transferring to the rest of your estate. Now, this can get very, very in the weeds. And so if we have more questions on this, or you think this is something that really does apply to you, absolutely reach out so that we can get you an appointment and help those needs be addressed. Now, one of the biggest benefits of the revocable living trust is, again, the fact that it avoids cost and delay of probate. So with your trust, assuming it has been what's called properly funded, which we'll talk about in just a minute, your estate can avoid probate. That is a huge advantage to 99.9% of our clients that motivates them to come in and talk about getting a trust set up for them. But then there are other components that can help ensure that a trust really is going to protect you. One of the biggest is that it protects your privacy. So in probate, again, unfortunately, things that you had kept private will become public. That can include who's in your family and then the finances and assets that were in your estate. With your trust, nobody has to see that document except the people specifically included in it. And so if you don't want someone seeing who your family members are or which assets you have or who's getting what, the trust is the way to do that. It also can allow for advanced tax planning. So with tax planning, we're now looking at a slew of taxes. This could be capital gains. This could be what is called the federal estate tax. This can be income tax, property tax. It can be pretty much any tax that you are concerned about can in one way or another be addressed in your estate plan. So if taxes are of concern for you, or you're concerned about making sure you don't pay a penny more in taxes than is absolutely required, come and talk to us so that we can walk you through how best to protect yourself and your assets. Another big one is that these estate documents allow you to avoid a court-supervised guardianship or conservatorship. The guardianship is avoided by naming the guardians in the will. So even if you have a trust, again, we will still create a will for you if you have minor children. And then we can avoid that conservatorship, which is, we'll talk more about later in this webinar, but it's essentially where the court appoints who takes care of your finances and who takes care of you. But if you've already put that in place, they don't have to get involved at all. And ultimately, every single thing that we do is customized to make sure that your wishes and not the courts are the ones that are ultimately carried out. Now, one of the questions I just got is, should a medical practice be included in a trust? That can actually be a more complicated answer. The short answer would be yes, But the long answer is it may not want to go specifically to a revocable trust. You may want to look into different corporation protections, that irrevocable trust, or the revocable. But it also depends on how the medical practice or any business is set up. And so with that one, I would very much recommend reaching out to us to make sure that we can address that in a lot more detail. Okay. One of the other questions I will actually answer towards the end, so just hold on to that one. Now, I mentioned on the previous slide something about funding a trust. So just because you have established a trust doesn't mean that your assignments, or homework as I call it, are complete. Once you set up a trust, there are certain assets that actually need to go into the trust itself. That, generally speaking, includes real property, so any homes or properties that you own, your checking accounts, savings accounts, and non-retirement stock accounts. So it's important to make sure that those things are transferred in, because if not, they will not avoid probate. We create tools, which I'll talk about in just a second, that help you to still avoid probate, but it does not mean the court is completely hands-off. Now, this can get very complicated depending on the assets you have, or just how much information we are pouring at you, and whether or not you can remember every single thing that we're talking about. So rest assured that not only do we talk about this during the webinars and other educational events that we put on, we also talk with our clients about this one-on-one in the consultations, in your signings, and even in your review appointments that happen down the line. One of the things we recommend to every single person with an estate plan is that you have it reviewed every 3 to 5 years. This allows not only for us to catch changes that may have happened in your life that need to be accounted for, and changes in the law that may need to be accounted for, but it also ensures that we can continue confirming, have you properly put the right assets in the trust, or is that something that still needs to be done? One of the worst things that we can see is someone who took the fantastic step of setting up a trust, but then did not take the step of putting the assets in. If that occurs, the problem is that those assets would still actually be subject to court after you pass away. The good news, though, is that we do put in a safety net for you, and that is in the form of what we call a pour-over will. The pour-over will essentially is there to be that extra safety net for assets. We still have to go to court at least one time, but our job at that point is to just tell the court, give everything back to your trust. Rather than the asset having to go through an entire probate and be stuck in that court cycle and timeline, we're able to get it given back to the trust and ultimately administered through there. So again, we understand life happens and things are either overlooked or forgotten or intentionally not put in the trust for a variety of reasons. But we want to ensure that if that happens, you're still protected in the long run, or that your asset is still protected. Now, this again, though, is something we never want to rely on. And so if this is something you have questions on, if you already have an estate plan in place and you don't know whether or not things are properly in there, come and talk to us. We're happy to help review that with you. Now, one of the other things that we talk about is the emotional side of estate planning. So a lot of what we just covered is about your assets and asset protection and things of that nature. However, there is the other side of all of us, and that is our stuff. With the stuff, these are actually, unfortunately, where we see some of our worst fights. One of the worst fights we saw was over a pasta colander or one of those strainers. And it was one of the worst because all of the kids ended up wanting this thing, and they were all willing to lawyer up in order to get it. And the reason they did is emotion. That was probably a $5 colander. So this was not a greed issue. This was not anything other than emotion. They had watched their mom use this for every single holiday and birthday. And while to you and I, it might seem silly in some ways that you guys fought over this and spent money to fight over it, the reality is a lot of times the stuff that the kids don't want while you're alive is exactly what they fight over once you are gone. So one of the things that we put in our trust is the ability for you to leave a letter of instruction. The thing that we're going to focus on today is the personal property component, your personal things. What that letter is saying that you are able to do is designate in writing who would inherit a thing that they may be emotionally attached to, or that you want to go to them specifically. This letter just has to be signed and dated. It does not mean a witness or a notary. And so it allows our clients a lot of flexibility to create as many of these as they want. And so this is something that we can help walk you through, but it's something that we also give you a how-to on when you come in and sign your documents. And again, this can take out a lot of the fighting and the hardship, frankly, that we see after a loved one has passed on. All right, so that was a lot of foundational information relatively quickly. So if, again, you guys have any questions on that, either feel free to reach out to us today in the chat and Q&A, or we'll have our contact information up at the end. Now let's jump into what are some of the pitfalls we want every person, whether they work with us or not, to avoid. One of the biggest things that we see is people have the wrong type of trust. By that, I mean, if your needs have changed when you first set up a trust to now, and you have not done anything to your estate plan, you could very well be leaving yourself open to risk, either for yourself, your family, or your assets. So with that being said, it goes back to what I mentioned, that estate planning is on your life cycle. So if you had no children when you first came to see us, you had, let's say, just gotten married, you're just starting out, and you do not have kids. And now we've set up a trust to protect the home you have, and we're really just concerned about asset protection. And then you carry on down the line, and now you have 2 kids. And tragedy strikes before the age of 18. They're still minor children, and you and your spouse are no longer with us. If you did not come in to update the guardianship component and include that in your trust, legally those children, at least for a temporary time, would become wards of the state. And we would have to go to court and ask them to appoint who could take care of and custody of your children. So that is an egregious example, but it is unfortunately one that we have seen. And it is just there to emphasize, again, if you set up an estate plan, it's not something you never want to take out again. We really do recommend people have those reviewed on that 3 to 5 year basis, not because we expect changes every 3 to 5 years, but because we know things happen, and that's a good timeline to ensure you never end up behind the 8 ball or left unprotected. Another big issue we see from trusts that were not prepared by Cope and Barger is that they don't address in detail or thoroughly or at all the issue of incapacity. Incapacity is something we're going to cover today in a fair amount of detail, but it is becoming, unfortunately, a bigger and bigger issue and a more relevant one for most of our clients. And so if you have a trust that does not properly address how to protect you or your loved ones in the event of incapacity, it can not only leave you vulnerable, but it could once again leave you subject to the court. And then not adding protective provisions that could benefit your family. Now, a lot of times these are more quote unquote optional provisions. However, these are things that can have profound impacts on how your family is protected and even your assets are protected after you have passed on. So if you are concerned about what happens to my estate and my spouse if I were to pass away and they remarried, we have protection that we can put in place. If you are concerned about, well, what happens if my child inherits a bunch of money from me and then his spouse and he get divorced, and now that ex-spouse is trying to take the inheritance away from my son? How do I protect that? We can put that in place. What if you have kids or any beneficiaries that really like to fight? We put in what's called a contest clause saying if you decide to go to court to fight and you lose, you're actually completely disinherited. It's a pretty big incentive for people to stay away from court and play nicely with others. And then, of course, what happens if you have a beneficiary that has some sort of substance abuse issue? You may still want to leave them their inheritance, but it may not be safe or appropriate to leave it to them specifically. There's parameters and managers and things that we can put in place to ensure the money is still there for their benefit, but that they can't use it for something that could really harm them. Ultimately, that is, again, all to say, updating your plan as life changes and ensuring you have an attorney that can walk you through these different protections and remind you of the options that you have available can be crucial to ensuring issues do not arise in the future. Just a few quick examples. Prince was someone who actually never created an estate plan. He had no kind of planning in place. And of course, that meant his estate had to go through probate. The court in this case does not care how wealthy you are. In fact, the wealthier you are, the happier they are to bring you right into court, because then they get their own fee. The heirs in this case paid $45 million in probate fees, which is astronomical and could have been avoided. So again, this is obviously an egregious example, and most of us are not concerned about a multi-million-dollar estate like this one. But what you have built and what you have earned deserves to be protected and not taken by unnecessary fees or taxes or any other costs and expenses. Then, using an example that really was quite heartbreaking, Paul Walker was the actor from the Fast and the Furious movies and passed away at roughly 35 years old. He had a minor daughter at the time who was not properly provided for in his documents. Now, thankfully, she had a living parent, but had she not, she would have become legally custody of the state for at least a temporary time. The other issue was that some of his assets then were also subject to probate. And so again, from a financial standpoint, they don't truly care who you were. If your estate was unprotected or not properly protected, it will wind up in probate court regardless. So hopefully that gave you a little bit of insight into what you can hopefully avoid now in the future. The best advice I can give any person, whether again you work with us or not, is to work with a qualified attorney. Our founder, Lloyd, has often said that you do not know the cost of an estate plan until you need one. And that is not the time you want to find out your assets or family are not properly protected. And so it is, again, really important to work with an attorney group who can ensure that these different things are covered so that at a minimum, you have the information necessary to make the best choice for you. But now let's transition over to the reality that is incapacity, conservatorships, and long-term care. Now, first and foremost, we're going to talk about the reality of incapacity, and I do this for two reasons. One is to ensure that if you're in a caregiver role, you understand that we are here to support you. Most of the people at the Cope and Barger Law Firm have personal experience dealing with an incapacitated loved one. And so this is something we are extremely passionate about and want to make sure our caregivers know they have a resource and a person or people who can come alongside them and encourage or point them in directions to assist in the long term. The other side of things, though, is that as you're going through these different documents and thinking about who you are going to name in the powers of attorney positions and in the different management positions, are they somebody actually capable of doing so? This is something that we talk at length about with our clients, especially for the ones that are maybe waffling back and forth between one person, two people, or multiple people. And the reason is you really want to make sure that, again, this is someone with a relatively good head on their shoulders. If they are somebody dealing with the medical, generally speaking, you want it to be somebody that can handle emotional decisions relatively well. If it is the person that would manage the finances on your behalf, it generally should be somebody who remembers to pay their own bills and can stay relatively organized. Because not only do they need to keep maintaining their own finances, they would now be in charge of taking care of yours. One of the things on this slide, though, that I do want to highlight is that if you notice a loved one becoming paranoid, suspicious, or even lashing out, I would very much recommend, if that is not in their general character, that you have them at least looked at for dementia or Alzheimer's. These are often the first symptoms that we are able to see, because as somebody starts losing the ability to trust themselves, they also start losing the ability to trust anyone else. And so paranoia and suspicion, and again, anger, become some of the first warning signs we see, and then can allow you to get ahead of it if they're evaluated on the early stages or in the early side of things. Now, one of the other components that we're worried about with incapacity is not just the emotional side or the who's going to be in those roles, but again, it's ensuring if you are incapacitated that you have already put in place the documents you need that would name who takes care of you or takes care of the money. If you do not, that is again where we're looking at the court getting involved to name who those people would be. In some cases, they would name exactly who you would want, but in other cases, they're just working off of a list of people that make in their minds the most sense, and that may not then be the person you would have wanted in that role. Again, basically, the court is appointing who would have already been named in those documents had they been set up in time. So if you are sitting here as somebody who still has the competency and capacity to sign legal documents, do not delay getting your powers of attorney in place. One of the big issues that we are seeing and why we stress those two documents so drastically is because we have consistently seen that seniors are concerned about becoming ill, but also that the rate of illness is drastically increasing. One of the reasons our seniors are concerned about becoming ill is the concern that they then lose the control that they had when they weren't. And one of the ways that our senior clients can then retain control, or even if you're not a senior client, just an ill client, that you can retain that control is by already having in place who takes care of you, the money, your family, and that everything can carry on with little misstep if you can no longer do it yourself. I mentioned, and I really cannot overemphasize, that the rate of illness has increased drastically. And with that increase, we have also seen a dramatic increase in the length of time that people are needing to stay in skilled nursing or nursing homes, and the cost of that care just increasing at a rate we cannot keep up with. And so this is why we talk to our clients about this, whether you are a healthy young client or you are somebody where this is becoming a more immediate reality. We want to touch on this for one really big reason, and that is the cost component. One of the things that a lot of our clients do not understand is that they actually have significantly more options working with the Cope and Barger law firm than they would going anywhere else. Let me start with the different programs, though, that people often hear about. The first one is Medicare. Now, with Medicare, that is essentially your health insurance. That is the program that once you hit 65, you can qualify for, and you can have your doctors paid for, the prescriptions covered, your health insurance carries on. If you are somebody living in the state of California, you can actually ignore Medicaid that you see on the screen, because that is the program that applies to the 49 other states. So we're only concerned about Medicare and Medi-Cal. The reason we are going to talk about Medi-Cal is most people think there is no chance that they would ever be able to qualify for Medi-Cal, because most people have heard you have to be 100% broke in order to qualify for that specific program. The reason for that being out there is Medi-Cal makes sure that you not only need to qualify, but that you financially qualify. Before I get into why there are drastic options that do not include the fact that you cannot qualify for Medi-Cal, I want to just put in perspective what the cost of care looks like. Now, this is for California as a whole. If you are up in Northern California with me, that last number on the screen starts looking like 17,000 plus, and all the others raise in accordance. So if you are in the San Jose area, you're probably looking at somewhere between $15,000 and $20,000 per month for some kind of nursing care. So it can be absolutely astronomical when you're looking at either getting care for yourself or having a loved one cared for. So then again, going back to how do we pay for that? Now, if you have the resources on your own, that's fantastic and is a great way to do it. But for many of our clients, and for us included, we don't have the resources necessary to pay that high of a bill every single month. And so then people start getting desperate or looking at other options. The reason I mentioned the Medi-Cal piece is we actually here at Kopp and Barger have a trust that allows you to keep your assets and qualify for Medi-Cal. Now, with Medi-Cal rules today, they would allow you to be financially qualified if you have a primary residence and $130,000. So if you are somebody who is concerned about Medi-Cal qualification and your assets are restricted to a home and less than that $130,000, you would actually be able to qualify for Medi-Cal if you needed it today. The problem for a lot of our clients, though, is they either have just over that $130,000 or they're drastically over that $130,000, but they still don't have enough that they could pay that monthly bill for any sustained amount of time. And so that is actually why Lloyd worked with the Medi-Cal rules and created this trust that allows you to preserve your assets and keep them and still qualify for Medi-Cal. Like I said, he worked with the Medi-Cal rules and they have been upholding this trust for just about now 15 years. And so we have watched this save our clients hundreds of thousands of dollars in unnecessary fees and things that they actually could have and do now avoid. If you have further questions on this, I very much encourage you to come in and speak with us. This is not something that is well known in the state of California, and that is frankly because a lot of estate planning attorneys do not have the proper tax background or advanced tax background that many of our attorneys here do. But they also a lot of times are more solo practitioners and may just frankly not have the time to dive as deeply into these more advanced estate planning areas. So again, that is one of the biggest advantages to this firm is we do have the ability and resources to do this sort of research, which in turn drastically benefits our clients. Now, anytime we are talking about Medi-Cal, again, we are looking at the best way that we can avoid the state making it that you have to deplete your assets. So if you are concerned about this, again, do come in and talk to us. I mentioned that $130,000 number, and I want to quickly cover that just one more time. Before July of last year, that number was as low as $2,000. So if you had a home and greater than $2,000, you would not have qualified. But that has again increased to $130,000, which means that people who would have been disqualified at the beginning of last year could now qualify. And so if you know anybody who thought about qualifying but didn't think that they were able to, I would recommend having them relook at the ability for them to qualify today. Now, this is specific to long-term care, but frankly, for any sort of planning, anytime you can do preventative planning, it allows you to have more choices and more options. If we are in the middle of an emergency, normally your options are extremely limited, or if nothing else, significantly more expensive because of the circumstances. So if you are able to do preventative planning, it extends your options and often makes sure that the cost is as low as we can possibly get it. Now, with that being said, for those of you who are already Kopp and Barger clients, I want to go through a couple of legal updates, but also with that being said, if you are not a Kopp and Barger client, one of the biggest advantages to working with us is that, again, we have the time to research and educate our clients. We do not expect our clients to go and research the law and then know whether or not the law applies to them and then whether or not they need to reach out to us. We reverse that. We do the research, we figure out if it applies to you or not, and then we reach out to you so that you do not have to do the work yourself. This adds a lot of peace of mind for our clients and allows them to rest assured that as things are happening, they would hear from us if it is applicable. Now, with that being said, if you are a current client and have not been to see us since 2018 and or have not had your documents updated, odds are you have some slightly out-of-date legal documents because of the different laws that have changed since 2018. So that deals in part with Medi-Cal. It also can deal with your retirement accounts. And then Proposition 19 went into effect just about 2 years ago, that drastically affects property taxes from an inheritance standpoint. Now, one of the questions I did receive is based upon the California law changes to inheritance, which is Prop 19. Might it be a good idea to sell California property and reinvest in states that are more friendly to the next generation? So the answer is yes and no. And the reason is a lot of our clients are looking to purchase property out of state so that they can avoid this. The problem can be multifold, though, with doing that. If you sell, you really want to look at, our capital gains going to be a large impact? And so for some of our clients, we actually did comparisons where it was the difference of what they would save in property taxes, or that their children would save in property taxes, versus what they would be paying in capital gains. So that's a really big consideration. The other thing to consider is, if you're purchasing out of state, what are the property tax rules and things there? There are other states that have significantly, despite what we think here in California, significantly higher taxes than we actually do. And so it's important to keep in mind where you would be moving to at that point. So again, I would recommend that that is something we would talk to you specifically about, or that you would reach out to your CPA about if you have one. If you don't have a CPA, or let's say a financial advisor or an insurance agent or somebody else that we ultimately involve when we're talking about taxes and things, we have some fantastic referrals for these different categories. We have built quite a network of professionals. And so anytime we need to bring in another professional, or we recommend that you speak with one, we can always recommend somebody if you don't already have them. Now, another question is, for a client that lives outside of California, how does the changes affect you? The biggest one on this page would be the SECURE Act, because that is a federal retirement rule that went into effect just now a couple years ago. And so that is one that, whether you're in California or not, because it is federal, that will absolutely impact you. Proposition 19 is one that, if you have no California property, will not affect you at that point at all. But the Medi-Cal authority could actually still impact you. So that is one that I would want to make sure your documents accounted properly, not necessarily for Medi-Cal, but at that point for Medicaid. And so I would recommend that if you haven't had them reviewed in the last few years, that we would still make sure that that was taken care of. All right. And then to start winding up and wrapping up, one of the reasons, and a main reason, that this firm was founded is because we believe that every single person has a legacy, and that that legacy matters. And so for many of our clients, as we're going through and talking about their estate plan, we're really talking about, how do you leave this legacy? Are you looking to leave a financial legacy? At that point, we're looking at your estate plan, your financial plan, and even your long-term asset plan for your family, to ensure that your goals can be recognized and accomplished to the best of your and our abilities. And then for other clients, they're concerned maybe also about the financial, but they're looking right now at the emotional. And so with this, we start recommending how to leave letters or stories, label pictures, write the history of an item or the family, things that really can leave a lasting impact for generations to come. If you have any questions on how to leave a legacy, or how your estate plan can impact that legacy, this is something we are extremely passionate about and would be happy to speak more with you on. Now, we covered quite a bit in a relatively short amount of time, so hopefully we didn't overwhelm you too much. However, we did, like I said, go through quite a bit. And so if you have further questions on what do I specifically need to set up, or what do I need to be concerned about as things carry on, and ultimately, how do I avoid all of those negative things that you mentioned today, come and see us. If you are already a client and you haven't seen us in a few years, we are very excited to get to see you again. And if you are brand new to Koppen Barger, we cannot wait to get to work with you. Kopenberger really is here to help you. Our entire goal is to educate our clients and ensure that they have the ability to make the most informed decisions for themselves. We hear from a lot of clients who have worked with other attorneys where they say, frankly, I don't even know what they really set up. I don't really understand if they set up the right thing or if they understood what I was saying, or I never got to meet with them after that initial appointment. And so I don't know if they're still even around. Those are never things you should be dealing with or hearing about an attorney. You need your attorney to stay involved as much as you are comfortable to ensure you remain protected years and even generations after that initial appointment. Now, again, one of the biggest advantages to the firm is frankly just the size. We really are able to put on education events all year round and do the research necessary to keep you and your families protected. We do have numerous attorneys with advanced tax degrees, so if taxes are a big concern for you, we are here to help. But ultimately, whether you work with us or you work with another attorney, you want to make sure they really are qualified. Estate planning can often seem daunting and even expensive in some cases, but trying to cut costs now and ultimately cost you and the family in the future. And so whoever you ultimately work with, you want to make sure that you trust them and that they are there to really work for you and with you. So thank you again for being here with me this morning. I hope that this was a good amount of information, and I am sorry if it can get a little bit overwhelming, but if you have any further questions or you need further assistance, we are here for you. Feel free to reach out to us on our website, to give us a call, email us, and thank you so much.